So more a comment than a question. I would like to say that this has been really our finest session. One of the most short, but one of the most inspiring sessions that we have sat through yesterday and today. And I do want to apologize on behalf of the organizers for the very sparse attendance here in the auditorium today. I know how disappointing it must be for Prasad and Martin and Jayashree to come. I know how busy you are, I know how well known you are, and I know that if you were teaching in a university in Europe or America, there would be hundreds and hundreds of people waiting and listening to you for hours and hours. And in your own country, you have very few people to listen to you. So I must thank you for taking your time off and speaking to us today, despite everything. I never expected such a rapid, premature departure of participants, but it's happened. And I feel very sad for it, but I must say you have, even though I know the subject very well, it's been inspiring to listen to the three of you today. Thank you very much.
Other two are also other two are also sitting here the same.
Yes, just one minute.
Yes.
While addressing a national seminar at Chennai, at the last session, there were only 9 heads. Quite often, whenever I will be addressing several of the seminars as usual, I will be just pointing out the same situation. It is not the number of...
Will you please introduce yourself, sir?
Oh, I am Justice P.S. Narayana from Andhra Pradesh High Court. It is not the number of heads which will be important. It is the reception. Maybe a few heads may be there, but if they are able to receive, that would be the best appreciation.
Yes.
I am Justice Indirajulu from Andhra Pradesh. So I want a clarification from Mr. McQueen. You have well exposed the problems of the Dalits who are doing this scavenging work, etc. But having studied extensively about these problems, what were the solutions, probable solutions you could formulate?
I think that's a good question, and what we have done is in our own Gujarat state, we have started a vocational training center. We are training between 600 to 700 Dalit youth every year into vocational trades so that they can get away from the caste-based occupations. That's number one. Secondly, we have gone and studied in the countries who have done tremendous work on resolving these issues. Especially Mexico has done a lot of work. What they have evolved is Mexico, if you see, the water tables are pretty low and it mixes with the water of Atlantic. So the entire things are getting polluted. So they have designed a toilet which is a compost toilet at the same time. So there's a chamber and a toilet on top. You separate the fecal matter from the urine and it gets composed. The urine is diluted with water and given to the plant straight, and this is smellless kind of thing which has been used in agriculture back. I think a lot of experiments has been done in Europe because everywhere there is shortage of water. I think even in Germany and in Switzerland they are adopting a technology called ecological sanitation. So we've been doing a lot of research in trying to promote this kind of toilet system in the villages also, so that it becomes an economic enterprise and at the same time it can eliminate mental shelving practices.
I think some sort of this practice has been carried out in Calcutta and in West Bengal, where these toilets have been constructed by the CMD, the Calcutta Metropolitan Development Authority, now KMDA.
Who is asking the same concept?
The problem in India appears to be if the Dalits are motivated from abstaining from attending to this work, probably they are attending to this work for livelihood. So there must be a kind of fund allotted for rehabilitation of those people. unless they are rehabilitated. So they will be affected by in two ways. First of all, they will be losing their occupation, and at the same time they will not get any employment. So there must be a lot of pressure on the governments, respective governments, to allocate sufficient funds, and at least in a phased manner, if they are able to find the alternatives, that is likely to lead to elimination of this manual employment in course of time in this.
Under the 8th five-year plan, government had allocated 800 crores of rupees for the rehabilitation. The problem is the government did not distribute more than 10% of resources to the people, because it has evolved a scheme where it gives only certain percentage grants and rest it makes as a bankable scheme. And the bank says that we will only look into your economic viability of repayments. So if the banks are not interested, and we had made this thing that this is the constitutional responsibility of the state and not of the bank. That's one major problem. But you're right in saying that this is largely an economic issue. That people are afraid that if we give up this, then what else is there? As Professor Bharat said, if I start a vegetable shop, nobody's going to buy it. Start a tea shop, nobody's going to buy it. So I think ultimately also it has got to do with the whole notion of untouchability, and that is where we have to do a lot of work on the social movement also. In Navsarjan, what we have done in Gujarat, we have redefined the whole Dalit concept. We are saying, don't and you now say that Dalits are an identity of people who are into this caste. We have taken the more broader definition and say Dalits are those who believe in equality, who practice equality, who protest inequality. And therefore Gandhi was a Dalit. And all the people who are sitting here are Dalits because they believe in equality. I think it is this notion which will take the whole shift away from the caste system and make it a more progressive nationalistic viewpoint.
A lot of mental attitudinal change also is required. I am told when Indians are going to America, they are doing their work by themselves. When once they cross Frankfurt, they exhibit their devilish attitudes and they try to exhibit their bossism on others who are weak and who are in dire necessity for livelihood.
Yeah, right. Yes, Dr. Thorat.
No, I have one question to Martin Makwan. Can you elaborate on this sumoto decision that Supreme Court possibly can take? Just like they do it, you remove the buses using gas, or some of the environmental steps they can give a deadline to the government. To what extent it is in the vicinity of possibility? Because there is a law against scavenging, and yet it is practiced. There is evidence. That is one. Second, to Jayashree, I think there's a much more compelling and frustrating kind of information that comes out. That what you are struggling against is the culture of discrimination and violence and atrocity. I am just asking her reflection that to what extent law can intervene. Are there limits to law to address to an issue which is essentially cultural, so ubiquitous, so widespread? Just the reflection of this, if she can.
I'd probably draw on the example. I was talking to a friend recently who's from the United States, and we were talking about the background of how, because the States went through its own struggle against racism between whites and Afro-Americans. And he said was, certainly, discrimination exists there today. We've seen it with Hurricane Katrina. Discrimination exists, racism exists across the world. But one thing that the law, when racism eventually, at least overt racism, died out in the States, was very much when the law started being implemented. So that law, I do believe, has a social function. It can, it certainly is not the end all of getting rid of this issue. That I think is true, but it plays a very significant role in terms of shaping people's attitudes, in terms of curbing those very egregious forms of violence. It sends home a message when a judgment is delivered by you all that says that, right, a woman that is raped, a Dalit woman who is raped, the charges will be framed under the SCSD Act. She will be, the perpetrator will be punished by severely. It does send home a message, and I think it's that kind of message that we need to continually send on home, as well as the social activism that we do. I think these are very complementary roles. What you all are doing here, Your Honours, and what others across the country involved in this social activism are also contributing.
I've got a little information to share. Justice Yadiraju rightly raised the question of rehabilitation. It is the accepted policy of the Government of India. And what happened was, the part of the 800 crores, in the budget 2 years back, 20 crores of rupees for rehabilitation. That was transferred to the Ministry of Urban Development. They diverted it, and then this year, latest budget, it has been abolished. So this is one problem. Then the Safai Karmachari Commission was created statutory commission 1994. 93 Act was passed, 94 posts were filled up. And even before the child was born, the date of death was fixed. And it was to end on the day when the aid plan would end, on the basis that scavenging will come to an end by the date, without raising a little finger to do what should be done for that purpose. And then it is being extended, and this time, when it expired, it has been an executive order commission which has been downgraded. Even though the statutory position, its voice is limited. Now that is also gone. When new commissions are being created for all sorts of purposes, with statutory as well as constitutional status. Then this act on abolition of scavenging, advice has been with the Government of India. Don't bring it under entry 6 of the state list. When each state has adopted, bring it under entry to the concurrent list, which deals with conditions of workers and welfare of workers. It is concurrent. Once the Parliament passes it, it's applicable to the whole country. So what's happening is, the leadership of India, after independence, has passed into hands, not from recent times, right from the beginning, that Constitution aborts untouchability, but Untouchability Act comes 5.5 years later. That type of casualness and then hostility in civil society, leadership, that is the great way. People will settle, provided signal comes from the top. Budget is being destroyed, education budget is being taken away. There was a provision for, somebody was asking, what would you for the poor people to come up from the seas? Residential schools were for residential schools of quality, so that people can compete. 250 crores was provided, not spent, additions made, and then snatched away by one government and being continued within a government. Change of government makes no difference to the fate of the Dalits.
Well said.
In Karnataka, we have been organizing these Paura Karmikas. The Safai Karmacharis are known as Paura Karmikas. Recently, I filed a public interest litigation to get them equal wages. There are some permanent employees of the municipal bodies and these contract laborers. So we asked for equal wages. I lost the brief in the High Court of the ground. It's a matter for industrial dispute. It should not be raised under Article 226. Be that as it may, we have succeeded in now focusing the attention of the government to this problem. And the government has started issuing orders, municipality by municipality, conceding that they should be given higher wage. Though not equal wage, they have now doubled the wages. To that extent we have succeeded. The petition is ready. We are making one more effort to bring the matter to the court. We hope we will be able to persuade the court to abolish the contract labor system so far as Safai Karmacharis are concerned and make them regular employees of the municipalities, in which way they get around 6,000 to 7,000 rupees per month as salary, as against 900 rupees which is now paid as contract laborers. Thank you. Yes, this is Ravaswan.
When I was in the National Commission, we have taken up the matter with the Government of India and Justice Venkatachalaya, Justice Verma, they have addressed 3 letters to the Prime Minister to see that manual scavenging is ended with a particular specific period. We have also suggested to them to amend the law and make it compulsory that anyone who constructs a house should compulsorily construct with the dry latrines and the wet latrines, and the dry latrines should be abolished. Simultaneously, we have taken up with the central government, urban development authority, as well as urban development department, ministry, as well as state governments, for the rehabilitation and allotment of the subsidy money for those who have been relieved from the scavenging, manual scavenging, that they should be suitably rehabilitated by economic schemes. I was in charge of the implementation of that also for that period. I used to travel across the country and I used to interact with all the authorities. Partly I was successful during my tenure, but I don't know what is the present system continuing in the NHRC. NHRC can take up this matter in a big way and see that all the persons involved in the manual scavenging, they should be suitably rehabilitated and the children are given education and employment.
In fact, the problem has worsened, as Mr. Martin has said. It was scavenging and carrying the nightfall on the head originally, which has converted into going down into the drain physically with the entire body and then risk their own life. How it is so far permitted after 55 years or 57 years of independence is still an enigma to any law-abiding citizen and a citizen with having any sense of decency. Yes, anyone else?
In the railways, it's a very big question. The railways, now they are, I understand that because the case is pending in the Supreme Court, they have asked for some remedy for this, and they say that it is very difficult, even for a sealed latrine. And even if you get the sealed latrine, then again it will have to be emptied by somebody. And also, in every railway station, only the bungee are doing this work. That is the case with the bus stands and the even offices and all the public districts. One more thing is that by introducing this pay and use latrine, somebody is making money. For urinal 1 rupee, for other things 2 rupees, 3 rupees, something like that, they are collecting money. Again, they are engaging only these people. So this is a very, very worst problem. At the same time, some are minting money on it.
Yes, sir. Yes,
so far as the public interest litigation is concerned, so in my personal view, there are certain constraints to the courts also. Whenever an application is filed, the court has to examine the pros and cons and the practicability in implementing the order. So in many matters, when it involves smaller amounts, involving a small group of people, the governments are coming forward and implementing those directions given by the courts from time to time. Where it is involving 1 million people, then the question of rehabilitation comes, and the other thing is the mental attitude of the owners of the houses has to be changed first. Governments in Andhra Pradesh, government has released so much money, central government has allocated amount for construction of septic tank latrines. In my district, the collector was, whenever he was meeting, he was telling me, sir, nobody is coming forward, we are offering them and we are ready to construct the toilets, but they are still suffering with this sentimental problem. They say that we can't have a latrine in the house. In villages, it is still a problem and they are unable to implement it unless a movement is brought and the mental attitude of the people is changed. It may be very difficult even if the court gives a direction to implement it. That has become a complex problem. So therefore, probably in course of time, a movement has to be started.
As we all know, ultimately, even after a judicial order, it has to be implemented through the same agencies which were originally expected to do that duty.
Yes.
So it is a order which is reluctantly accepted and often it is defeated by delay or other objections. And a major objection which comes in a suo motu proceeding is, one of the objections is that the government does not have resources for this. You can't force us to allocate funds for this purpose. Therefore, the fight is required to be carried on all fronts, bringing pressure of the public opinion, bringing judicial order where it is possible, then persuading the representatives of the people, then pressurizing or bringing pressure on the executive authorities who are in charge of that subject. These are all the fronts on which one has to fight to bring about even a little change when it is on such a vast scale. Yes,
my respectful suggestion is, in the courts also under the public interest litigation, Supreme Court has evolved what is called continuing mandamus. Keep on issuing directions. And in this matter, though the law is only with the Union of India, actually state governments have to implement it. Therefore, what is necessary is Union of India should be made a party. State government also should be made a party. Continuing orders keep to be issued for implementation, asking the others how far they have implemented and enforced the directions. If that continuing mandamus is pursued to a great extent, relief can be brought about. Courts can adopt that procedure.
I would like to share one thing with the permission of the chair. In Andhra Pradesh, the Safai Karmachari Andolan had taken the demolition drive because it's the Safai Karmachari Andolan filed a public interest litigation in Supreme Court, and we had taken the demolition drive in Nizamabad district in Ellareddy court. In the court premises, we found dry litter. When the activists trying to demolish that symbolically, the magistrate opposed, and he has given in writing that is the property of the court. That document that we produced in the Supreme Court in the PI. That's even the perception of.
So, Mr. Consul, Colin, shall we now conclude?
So the session gets concluded, but we have a last session which we are contracting drastically. But we will, if you don't mind, sir, they are ready to do it.
Yes.
That is to say, Mr. Paul Divakar and Mr. Vincent are ready.
Yes.
If you can continue to chair, sir, they will make a very brief presentation. Very brief presentation.
We are running late. Therefore, I would request the Honorable Speaker to be as concise and precise as possible. But please do convey what you have come to.
Thank you, Honorable Chair. Just briefly, this session looks at what are the stand that UN has taken, and presently what is the position in the UN on this whole issue of caste-based discrimination. A small handout which is spiral has been handed out to you. The one previous to that. There are two. While the formation of the UN itself, this issue has been quite vigorously discussed. Baba Sahib Ambedkar has raised it during the whole context of the Roundtable Conference, and in the whole period while the countries were going through the rigors of Indian independence and other British-held colonial independent states were going, caste was very much an issue, and the Pandit Nehruji, when he was doing this whole League of Nations, there was a lot of discussion on this. And India itself in 1946 has raised this issue of apartheid in South Africa. But the fact is, while the Universal Declaration was brought in, the whole issue of caste was marginalized. Race actually took the predominance, even though as an issue, I think we cannot compare, but as an issue, race as such has been much less researched and much recent phenomena, but race has been predominantly covered in the whole aspect of the Universal Declaration of Human Rights. And in that actually debate, when the whole International Convention for Elimination of Racial Discrimination had brought out later, much later in 1961, it is Indian government who said that we have to have a clause called dissent under the list of discriminations, so that it would include a specific group called caste. I mean, it's very interesting how, despite all this, the whole caste as a causative factor in the list of discriminations has been left out, and we feel it has been a deliberate attempt not to address this issue when many other issues which were less poignant became to be addressed. And the 5 decades after that, caste has been totally invisible. Caste-based discrimination has not been addressed as caste-based discrimination in the UN. You have International Covenant for Racial Discrimination, you have Civil and Political Rights Convention, much later you have the CEDAW Convention for Elimination of Racial Discrimination Against Women, and the Child Rights Committee. In all these, the issues of specific issues, as I think as we have expressed that, okay, women's issue was discussed, the civil and political rights was discussed, race as a thing was discussed, but definitely the issue, specificity of the prevalence of the caste-based discrimination has not been touched. Until 1996, when because of certain shadow reports that were done, and the situation of the Dalit and the caste-based discrimination was brought, the country report of India, while it was being examined by the committee which is monitoring the ICERD convention, which is CERD, they've said that, affirmed very clearly that the situation of the SCs and STs fall within Article 1 under the next one. Yeah. And then also they said there's widespread discrimination and human rights abuse and impunity, and therefore this impunity needed to be addressed, and ICERD said that even though Indian government does not think caste as a thing which comes under race, but need to be treated under the purview of the CERD committee. And similarly after that, ICCPR had brought, in the next slide you will see, the Human Rights Committee has brought it out, saying that members of the SC, SC, and the OBCs, they endure disappropriation, social discrimination, and therefore, by de facto, these things needed to be brought in under the purview of the ICCPR. Similarly, much more powerfully, it was brought in under CEDAW, where the whole Dalit women's question was discussed at great length in 2000. That was also the period when the whole preparation for the World Conference Against Racism was being done. So there was a lot of agitations and also issues that were brought around in the South Asian context. So CEDAW committee also very clearly said that this needed to be brought in. Then of course the whole lot of special rapporteurs mentioned this since then in 1997 and all. I will not go into it for lack of time, but it was primarily India's position was the next one. The next one. India's position was always caste is not race, and therefore it cannot come under the purview of CERD or purview of ICCPR or CEDAW, or later they also said the same thing at the UN World Conference. But having said that, yes, it is a kind of a discrimination. It's so complex, and it requires change of attitude. It is so old that we cannot do it away in such short time. And but having said all this, it refuses even to today to submit its reports or really accept the convention for what it is. Then we see in the whole World Conference Against Racism that for the first time a concerted effort by many Dalit organizations, primarily in India, but also across the South Asian countries, have made it a major issue. And I think all the human rights organizations who have participated in the World Conference Against Racism have brought this issue so powerfully that it became one of the three major issues that needed to be addressed. African descent, the whole issue of the blacks, not just in the US but across the continents, the Palestinian issue and the Dalit issue. There in the whole preparation, NCDHR and many organizations who have supported the National Campaign on Dalit Human Rights tried to bring this as an issue in the agenda, but there was such a huge resistance, primarily from the Indian government, which went very aggressively against any other member of the United Nations which supported this particular issue. We have seen country after country which has withdrawn their support to include this in the agenda. And we're very, very surprised, and very much so I think Justice Ramaswamy Garu is here. The National Human Rights Commission under the leadership of Justice Ramaswamy and Justice Virendra Dayal have made a very poignant point at the submission at the World Conference Against Racism, which really stood saying that let us not play semantics whether caste is race or not. The discrimination that is being expressed and experienced by the Schedule Caste formed under the scope of the convention, and therefore we must begin to address. And I think it's a very bold stand which really pierced the glass ceiling or the glass wall that existed till then. What happened in the World Conference, of course, it did not figure India very successfully blocked, but by blocking, what it did raise was the whole interest, global interest in this whole issue. And also, after that, in the CERD, the Committee of Elimination of Racial Discrimination, held a thematic discussion in 2002, which brought out this whole issue once again, and then passed a historic general recommendation, which by, it's the prime judgment which a committee, international committee can give under the UN. It's called General Recommendation 29 in 2002, I think August, which said that it affirmed that discrimination based on descent includes discrimination against members of the communities based on forms of social stratification such as caste, and it condemned the descent-based discrimination such as discrimination on the basis of caste and similar systems across the country. And it went into various measures that needed to be taken, review, enact, amend legislation where it is not there, and review where it is there, and have, very clearly, very systematically it had gone in, and to say how do we promote, how do you integrate, and then how kind of fair and equitable law enforcement can be given out, including legal aid, full cognizance of this in the judicial decisions, recruitment of members from discriminated communities in law, and also training of public officials to address these prejudices. Because the reason is, especially in countries like India and Japan, where you have the descent-based discrimination, it is not that act is not there, it is just the area of implementation. What was also surprising is there's a map, if you can, one more. this kind of, it's the first time in the world that we felt that it is not just in India. Of course, it's South Asia. Primarily, I mean, the majority of at least about 200 million in India alone, and you have in whole of Pakistan, Bangladesh, Nepal, and Sri Lanka. But very strangely, in Japan, which is supposed to be so advanced, the Buraku community is facing similar kind of a thing. So it's not just the whole aspect of economic development that will root this out, but I think we need to have a different angle where the social aspect and the mindset of discrimination and the hierarchical status that we are giving is a crucial aspect. But just keep the in Myanmar also. But in Africa, for the first time it has been brought out, like in Nigeria, in Algeria, in southern Mauritania, Mali, Libya, Somalia, Kenya, Ethiopia, you still have similar kinds of discrimination, and now there is a global movement to address this whole discrimination, because earlier India unnecessarily used to feel that India alone is being directed as a country which has this. No, it is just not a case of India, it's of Asia and also in many other countries. And in all these you see that is similar to the caste mentality, caste-based discrimination is prevalent. Next slide. After that. The whole area of purity pollution, whole area of forced occupation, it's existing in all the countries that you have just seen. Untouchability, forms of untouchability, separate settlements, segregated settlement, and not allowing them into hotels and restaurants. Denial of services is still taking place. Access to land is very prevalent. Hate speech and prohibition of vehicles, what we have seen, all this is there. I would just say that why are we, the last slide in this, if you go back, one more, no, one more, yeah, next. What are the whole implications? I mean, don't see that anything passed in the UN is a thing that is going to affect the marginalized communities like Dalits in India. But what it does is, it legitimizes the interventions that are taking place. It informs the whole jurisprudence, and it takes this issue to various levels as a serious issue that needed to be addressed. It is not UN advocacy is not to replace the kind of legal action, the kind of social mobilization that needs to take place at the grassroots, but it is to supplement, and this kind of a space has been created because of the present recognition that the UN is giving. And I would like Vincent Manoharan, who is the General Secretary of the NCDHR, to just share with us the aspect where the appointment of special rapporteurs has been done because of this large mobilization and this new informed recognition of caste as a discrimination coming under the purview of the United Nations. Thank you.
Thank you, Paul. The Honorable Chair and the Honorable Members and my friends, I will skip the slides here. I will take only 4 to 5 minutes. I want to pick up from what Paul stopped. Number 1, even today the UDHR does not speak anything about caste. It speaks about all various other forms of discrimination, which includes race, gender, religion, language, all other forms of discriminations in the world. But it does not speak, even today, anything about caste as a source of discrimination. Number 1. Number 2, because of the interventions made in various forums, in treaty bodies and the charter bodies, including UNCHR, the commission, the CERD has declared that the situation of Dalits comes very much under the scope of Article 1 of CERD, which has given a kind of a strength for us to go on raising this issue. Because of this, the United Nations Subcommission for Promotion and Protection of Human Rights has taken up this issue seriously. It has appointed as one of its 26 experts It has got 26 experts from all over the world, and they meet every year. And they appointed in 2001 the person called Gunasekara from Sri Lanka to study the situation of people who are coming under work and descent-based discrimination, not saying as caste-based discrimination. And he presented his report in the year 2001. But he was withdrawn from this country in 2001. Therefore, the UN subcommission again appointed two other persons. One is a Swedish, Iceborn. The other one is Okota, the present special rapporteur. He is now appointed. These two continued the study and they presented a report in 2004. In 2005, again, Okota gave a kind of a guidelines and principles for this. Because of taking this issue at the United Nations Subcommission, the United Nations Subcommission last year in August, they passed a resolution to appoint two of its members as special rapporteurs to study the situation of all these communities which are coming under work and decent, and also to give some guidelines to eradicate this problem. This is what they said. But as a procedure, the UN Subcommission's resolution should be adopted by the Commission on Human Rights, which was done in this year, April 19th, when I was also sitting in the Commission on Human Rights. This happened. Now, let me say something about the nature of the state. Number one, the UN demands from these special rapporteurs to submit a preliminary report in the year 2005. Now, in this year they have to submit a report. In 2005, already they have submitted preliminary report. Then they have to submit a kind of a progressive report after having studied this. That will come in the year 2006. They are going to present it. Then the third year report will be called as the comprehensive report. What they should study is that they have to study in 4 or 5 areas. Number one, first they have to identify the communities who are in the world. Now, the map has shown that in the 18 parts, including five states, member states in the South Asia. So the number of discriminated communities are in the world. Now they have to take out a list and also the best practices that are very much there, and they have to collect this as some information. Number two, they have to study about the affirmative actions that are already prevailing in each state in the form of constitutional remedies or legislation, judiciary, administrative, educational. These are the matters that they have to study. Number third is, what is the response of the commissions, like National Human Rights Commission and other commissions, to address this issue? They have to study. Number four is, they have to listen to the NGOs and the civil society organizations. This is what the scope of the study states. Other than that, they have to get the support from they have to get the solidarity and support from the special rapporteurs already who are functioning in the United Nations organs and agencies, especially the special rapporteur on the commissioner, special rapporteur on contemporary forms of racism. Also, the third committee's support also they have to get. This is what they say. Also, they have to get the support from ILO and also from UNICEF. More than that, they have to take up the list of communities, number of people affected by this kind of discrimination, background information they have to collect, and also the types of discrimination that they are undergoing. Lastly, how much period that this kind of discrimination exists. All this will come under the scope of this study. So these are going to be there. But what they have to say is, by studying all this, they have to give a kind of a monitoring mechanism should be there. They have to give a guideline. How the monitoring mechanism should function in order to implement the constitutional, legislative and the administrative measures. They have to give guidelines. That is what the mandate given to them. The other one is, what is happening to the cases filed in their respective countries? Whether they are able to get the right kind of judgment, right kind of remedy from them. All these could be studied and they should give the guidelines. So this is the kind of study which is undergoing. Now, as far as our information goes, that Professor Yokota from Japan and Professor Chung from South Korea are the two special rapporteurs. They are also going to visit India. Now, I think here Professor Thorat is also sitting. We are trying to invite these people to address in some universities. They will come over here. We will make use of their visit. We will present all our papers, and also they are going to visit Pakistan, and there are attempts are there to make them to take to Africa also to understand the persuasions of the communities are there. So this is happening, and we as NCDHR, also along with many other Dalit organizations in this country, the questionnaire which has been already issued by Yogata and Pro section, we have to collect all this. We are going to bring out a kind of a shadow report, and we are going to give it with the help of the IADS, which is headed by Toranji. So this is happening at the UN. Because we have been constantly taking up this issue at the UN various forums. Now special rapporteurs are appointed. What we call is that at least the silence of UN is now broken. We are the broken people will always say, and we have broken the silence of the UN for the first time. At least this study will bring out a number of issues that which could be addressed in future by every state. Thank you for the discussion.
Thank you. Any questions from the House?
In the National Human Rights Commission, before the Durban conferences, we have organized 2 conferences, one at Bangalore and another at Delhi. And we have independently formed an opinion that this issue should be taken up in the Durban conference. I have taken up as a representative of the NHRC, myself and my brother Virendra there. And we have said that caste-based discrimination is an issue that could be addressed in the international fora, including UN fora, and that remedial steps should be taken within the constitutional means framed under the Constitution and the laws. And no external agency could impose any law outside the Constitution, because it is a form of the constitutional mechanism. That scheme was approved by the UN Charter also, and now Resolution number 27, as has been pointed out, has accepted in the SADC committee recommendations, and now therefore it is the NHRC that has to take up the matter. Before my term expires, we received that communication, and then we, myself and Virendra there, going into that how far we can interact with the government and see that there is even recommendation could be implemented by various programs of action. I do not know what has happened thereafter. I request you, these organizations, to interact with NHRC, because that is primarily responsible for implementation of the UN Charter. Therefore, you can interact with them. What are the action taken program evolved pursuant to that recommendation of the number 27, and what are the steps taken by the NHRC? Unfortunately today, NHRC representative is not here. Therefore, you have to interact with them because they are associated with this conference. You can also interact with them and take up this matter. And they should be responsible to give answer to those 2 special rapporteurs appointed pursuant to that recommendation.
Thank you, sir. If there are no other questions, Mr. Gonsalves, should we conclude now? Will you have a final word?
Sir, I'll do the final word from here, sir. Actually, not much remains to be said, so we've come to the end of a wonderful session, both yesterday and today. And this is the second of our judicial colloquiums. The first we had on the right to food about 2 or 3 months ago. I think, sir, you were there for that as well. Justice Bagheera, you were there for that, where 60 judges came, and there were very moving presentations made about hunger in the country, and we were surprised to find that senior judges of the high courts coming up to us and saying we are really thankful to you because we didn't realize that this was the level of hunger in the country. And it's the indication actually of the need for these kinds of colloquium, because the interaction between people in the field, social workers and activists on the one hand, and judges, is very poor. This has been a nice colloquium, so I only regret the participation now. It's been a very good colloquium yesterday and today. And I want to thank everyone. Particularly I want to thank the NCDHR for the effort they put into this thing. And I know they are a little bit disappointed by some of the reactions that came in the morning session, quite frankly, but that's the way life is and that's the way our legal system is. And I want to thank them for the extraordinary effort that they took, and particularly the victims who came here in the morning session. They've travelled from so far, and they've travelled to a very inhospitable state, very cold, and they came here for the colloquium. That's all, sir. And I want to thank you and all your brother judges who are here today for staying with us.
Thank you. May I also take the opportunity of thanking all the persons, as Colin Gonsalves said, who had come all the way to expose the judiciary to the thinking which is going on outside. And it was indeed a privilege to have the inputs from academicians, from the social activists, and from the workers who are really working at the ground level. It was a very important, very essential input which we have got here. I must thank all of you, and it is good that those people who are to be thanked are here. That I thank all of you on behalf of the judiciary, that you have provided a very essential and a very important input to our knowledge. Thank you.
Tea is available outside. Tea. Yes.